All right, we're are we good to go then?
I've got green on my end.
Okay, all right. Welcome to Squall not being good at the show. Anyway, welcome to Squall's segment on my YouTube channel called Five Good Questions. If you see by the visage of the fellow in the image that I'm displaying, that is Leonard French, YouTube's and our favorite copyright attorney.
Thank you. How you doing,
So,
everyone?
welcome to the show.
Thank you.
All right, so
Thank you for
we'll go
having
ahead
me.
and thank you for uh, agreeing to this interview. All right, so let's go ahead and jump into the first question. What is a copyright attorney and what do they do?
Well, a copyright attorney, first off, is an attorney. They represent people in court, and they are specially trained to be an attorney. And in the world of attorneys, there are different there are attorneys who focus on different kinds of law. And I choose my words very carefully because there's actually a law that says any attorney can be competent in anything under the law. Now that doesn't mean that automatically every attorney knows everything. In fact, it's our duty to know what we know and to know what we don't know and to refuse to give or take business if we can't be competent in what we do. So when I say I'm a copyright attorney, it just means that I focus my practice on copyright law and not that I'm better or worse than any attorney. Just that I focus on copyrights. Some attorneys focus on patents, some attorneys focus on personal injury. Um, Many people watch criminal defense attorneys and prosecutors on TV. I just focus on copyright law. So that just means that I focus on one of the specific areas of intellectual property law that are currently recognized in the world of well, all law.
All right, so
Oh, I
well,
guess then the follow up question is, what do they do? You want me to keep going?
yeah, go ahead.
Um, so copyright attorneys help people protect a specific kind of intellectual property right. So everybody's familiar with property. You can own something and hold it, and you have this thing, this dollar or this thing in your hands. A copyright or a patent is more property of the mind, of humanity's creation. Someone has developed an idea into something more than just an idea, but a way to use that idea. And so the law recognizes the value in that. And so copyright attorneys protect copyrights, a kind of intellectual property law for people who make creative works, videos, movies, music, uh, anything that you can write down or express yourself through is pretty much copyrightable. And so we help people protect that. And in 2017, that means the world of new media, the world of YouTube, the world of the internet and Twitch, and all of the laws that maybe didn't get used in these new ways earlier now have to be used in more complex ways. Contracts become terms of service and privacy guidelines. Privacy law becomes now something that every company that has a website has to know about. Anybody who gathers any customer data, et cetera, et cetera, et cetera. So there's all these new opportunities for attorneys to focus on new things. And so a copyright attorney focuses mostly on protecting the creation and enforcing the rights of owners of copyrights.
Okay, now, but speaking of new media versus old media, okay, if I were to take like the shortest verse in the Bible, Jesus wept, could I copyright that and make money off of it? Because the Bible is not really a copyrighted work, is it?
Not anymore. No, it well, be only because of history. If the Bible was written today from scratch, brand new,
Okay.
yes, it would be copyrightable. And many publishers of Bibles will add something to their publication in order to be able to create a new copyright in it. But back in the day, when it was written 2,000 years or so ago, depending upon your view of religion, uh, well, first of all, it wouldn't really have been recognized as copyright wasn't recognized as a thing, but at least not under any written law that we have. But if you took that today and tried to copyright it, no, because it's not an original work. But if you wrote that today, if you wrote something that simple today and tried to copyright it, it would be copyrightable as much as it's creative. So if I said 2 plus 2 equals 4, that's a fact. That's not my expression. That's not copyrightable. But if I said rainbow arcs through the sky with the wonders of a yada yada yada, that is minimally creative, at least a little bit creative, and therefore copyrightable in the sense that it's now been captured by our audio and video recording and fixed into our computer memories, and that work is copyrighted. That answer your question at all?
It does. It does pretty much.
Have you interviewed many lawyers?
Not actually. You're the first lawyer I've interviewed, so
both of us, I'm sure.
Yeah, but I do understand that sometimes you guys, and I'm not trying to be, I'm not trying to generalize.
You can
but
generalize. It's okay.
It's mainly that attorneys, lawyers, they speak in an eloquent pattern to try to use their words to go around things.
Absolutely. I'm 110% guilty of that as well. As you saw, like my opening lines with the whole, by the way, copyright is focus, not specialization. That was more for general than it was for, trying to disclaim anything. But that there are nuances, and that's what the law is we're studying all of those nuances and learning where all the pitfalls may be.
And in each state and in each country, the copyright laws may be different.
In each country, copyright is something that's been established now by treaty. We would call it a federal law in the United States. Other countries aren't a federated conglomeration of states. Maybe the EU is considered a federated nation of states. It's not, but there's treaties that govern those things, and so states cannot change copyright law. And it's kind of funny to see when they try to use it, they often use it wrong. But yes, by treaty, copyright law is handled by the federal or the country level.
Well, like one of the things I just thought of was, like, in Hong Kong or other countries, you see people selling bootlegs. Well, not just in Hong Kong, but all over the world, you see people selling bootlegs of copyrighted works and other such illegal, like, use video game as an example. They would copy a video game and take it to the street and sell it to somebody for like pennies on the dollar and still make a profit off of it.
I'm sorry, what's the question in there?
I don't know what the question was.
Oh, okay. Hey, no worries.
Okay, all right. But that is illegal, right? To take somebody else's copyrighted work and produce it yourself, and then try to sell it for a profit, because it's not your work; it's somebody else's.
It is illegal. Sorry, I'm trying to correct the audio issues that someone was telling me about here.
Oh.
Sorry, one last time on that one.
It is illegal to sell somebody else's copyrighted work as theirs.
Without more to your hypothetical, yes. If you just copy something and sell it, you're usually in violation of someone's copyright, unless that copyright has expired, or you've made a fair use of it, or you've licensed it, that sort of thing.
So, like, if I were to take somebody, let's use the Beatles, Let It Go. If I were to turn it into a rap song, and that would mainly be sampling it, though. But if I were to turn it into a rap song, I would be able to copyright it as my own transitive performance and be able to sell it myself.
At some point, yes. But you're right. That's right now at the forefront of copyright law is how much do you have to sample and when does it become transformative? The best example I can give is Greg Gillis in Girl Talk right now. He mashes up hundreds of samples from um, all sorts of mainstream music, including taking the hook or taking the core beat from something and using it for exactly its intended purpose to remind you of that work. But he's using it in such a new and arguably transformative way that he's making brand new songs. And what I've read, I don't have any inside knowledge on that one, but what I've read is that Hollywood really doesn't want to take him on, or not Hollywood, the recording industry really doesn't want to take him on, because if they get some legal precedent in his favor, then that just opens the floodgates for everyone to do what he's doing. But it's already kind of happening, although it's not maybe floodgates. People are starting to figure out that they can use samples in certain ways and they won't get in trouble. But it's also on the borderline. So if you use samples, you should be prepared to experience some of the conflict that will happen as these laws get sorted out.
Okay, hold on. Just a moment. All right, there we go. Oh my God, I look.
It's the gain on my end, guys. Let me see what I can look up, or if I can
How high
boost the
is
gain.
this guy? Aaron, really? I'm not high at all.
Maybe he was talking about me.
Oh, okay.
I'm high on life, Aaron. And maybe there's a lot of light in my eyes, and I only woke up a little while ago. But I'm looking.
It's a runner's high, right?
Oh yeah, because I run at my sitting desk all day. Why can I not boost my own audio? I can turn the gain up, but we're going to start clipping at some point.
Oh my, that's okay. This.
All right, there we go. Let's check 1, 2.
You're still fine on my end.
Oh, I'm adjusting my audio for my stream, which was low.
Okay.
And now I think I may have made it a little bit. You're going to be the low one now.
Yeah, Osmoaxis says
okay.
now they can barely hear you. But then turn up your headset. Turn up your speakers.
Okay, it should sound a little bit better now. At least the levels on my end look better. Sorry for the technical difficulties.
Yeah.
Where were we?
Okay. Well, let's go ahead and move on to the next question, I would say. All right. How do you become a copyright attorney?
Well, that's the first part of that is really easy, and the second part of that is really hard. You can become an attorney, and then you can start working in copyright law. To become an attorney, you first have to go to undergrad and get a bachelor's degree. At least in 98% of the circumstances, there are some very minor exceptions to that don't make you the same kind of lawyer as everybody else. So most of the time you have to go to get an undergrad degree and then go to an accredited law school, which is at least 4-year program for undergrad and a 3-year program for law school. And then you have to take and pass a state's or country's bar. When they say pass the bar, that's literally the license exam for becoming an attorney. Once you have passed the bar and then waited a couple months for them to score the exam and actually give you your license, then you have permission to start being an attorney. And that's when the hard part starts. You have to go get clients and get a job, or get a job, or make your job getting clients. And if you want to practice copyright law, how is a brand new attorney going to convince people that they are worthy of practicing copyright law, being hired, if that they're competent? So you more or less have to go find somebody to mentor you, or get into a firm. Getting into a big firm is often very difficult because there's a lot of competition for that. I, for example, did not qualify to be admitted into one of the, or hired into one of the big firms. So what I did right out of law school was start advertising my technical knowledge in any sorts of cases, but particularly copyright cases are what I had my eye on. And after a few months, I did start getting phone calls from people who were getting sued for file sharing cases, since those are highly technical. People would go to an attorney, and the attorney would need a very long time to understand what was going on in this highly technical case, where I could explain it in a few minutes. So I would either work with their attorney or I would become their attorney and represent them. And I started not necessarily winning these cases, but I started handling them about as best as they could be. Think of somebody who gets a speeding ticket. The cop may have caught them. They may be dead to rights, guilty of 15 miles an hour over the speed limit. But I can still do a good job in getting that negotiated down to a lower fine or less points, or not having it affect their commercial driver's license, or not having it affect their previous charge or something like that. So we figure out the personal nature of the situation and then minimize the damage. And so in that sense, I started having success and eventually built that into a larger copyright practice. At one point, I discovered the reality of the phrase, the world is run by those who show up. There was a local court that had a copyright case. We don't see them too often in Pennsylvania, so I put on my suit and I drove down to just watch the copyright case. It wasn't even the trial, it was just a simple hearing. What was way more valuable than I ever thought at first was meeting the judge, meeting the plaintiff, meeting the plaintiff's counsel, meeting the scared defendants and their attorneys who didn't know what was going on, introducing myself, explaining the technical side of things, and then it turned out we all worked together defending the 5 people who were accused in that case. So that was the real start to my copyright career. And so that's how you become a copyright attorney, is really just kind of by hook or by crook. Well, not by crook in the literal sense, but by hook or by crook, pushing your way into the industry that you want to work into and not giving up.
So with that case, you kind of got you got a little bit of coverage, but you also got people who are like, hey, this guy is good at what he does. We should tell other people about him in case they have this similar situation happen.
Yes, that really helped. It helped that it was one of the first cases. It was a landmark case as well. But I don't want to toot my own horn. I was green in the pasture. I had no idea what I was doing in federal court, in federal litigation, with 6 digits at stake. And I was very grateful that I was with these other 4 defense attorneys who could explain what I didn't understand, just as much as they were grateful to me that I could explain the things to them that they didn't understand.
Now, are any of these cases that you discussed, are they public knowledge? Are you able to share them? Are they classified as their information that's sealed that you cannot disclose?
No, this case is public knowledge. I can't discuss any confidential information that's not public knowledge, but frankly, most of the case is public knowledge. I've actually made a video on this case. This is one of my videos, the $241,000 copyright judgment for 5 BitTorrent downloads. That's what this was the landmark case. The judge called it a bellwether case. The bellwether is the lead sheep in the flock, so it was kind of an appropriate moniker. But while I found the case to be very enlightening, the people involved did not, because at that time no one really knew that you could get that kind of not a fine, but that kind of a judgment for just a few downloads on the Pirate Bay, and that they could find you, and that 5 defense attorneys could put their heads together and still couldn't get the case dismissed. And the judge would want us to go into discovery, and discovery meant questions under oath to all 5 defendants. And answering questions under oath by lying is a criminal offense, and these defendants were only accused of a civil offense. Many of them settled their case right away, and then the last defendant did not. The last defendant was not my client, and so I can talk about his case. I don't have any confidential information about him. Well, Not, I do have one thing that I can't say. I can't say how much he eventually settled his case for. That's it. But the rest of his story was that he had wiped his hard drive after he received the subpoena for it, and then reinstalled Windows, put that into an encrypted USB enclosure, knowing that, well, maybe I don't know if he knew, but he should have known that when they got his hard drive, they would take his hard drive out of the encrypted USB enclosure and then not be able to read it. They'd be able to read the ones and zeros off of it, but then they wouldn't be able to get any data further out of that. So eventually, a very intelligent, in my opinion, very intelligent forensic examiner figured it out, went against, I mean, after making copies, went against the initial procedure of taking it out of its enclosure, put it back in its enclosure, and tested it then, and lo and behold, he could read the drive and boot Windows from it. They figured out it was a fresh install of Windows. They subpoenaed Microsoft. Microsoft responded with saying that 3 days after he received the subpoena that it was reactivated, and the judge multiplied his damages by 10. So instead of $24,000 in damages, he was hit with $240,000 in damages for 5 downloads.
So the basic gist of this is, don't wipe your hard drive if you have to take it to court.
Don't destroy evidence. You can easily turn a civil offense into a criminal offense. It only works if you get away with it, and that is not legal advice.
The thing about lying under oath in court, that's called perjuring yourself.
Stream is buffering. Stream disconnected.
We're good on my end.
My stream disconnected. No?
Yeah.
Okay, Max says it's working. I
It's
still got green over here, so I hope it's on their end and not mine. I think I'm recording, so we got this for a repost anyway.
Yeah, we do. Okay. Brian says bury the drive in the backyard. That's not a good idea.
It's not a good idea. So from a strictly legal professional standpoint, I obviously cannot condone that anyone ever do anything like that. However, from a reporting aspect, from my free speech, not under my responsibilities as an attorney, I can say that people have tried that and some have succeeded. So I can see why people get the idea where they can do that. But the damage is so much worse if you get caught. You remember the Bill Clinton scandal back in '96 or whatever? It wasn't the sexual impropriety. He was in trouble for that already, but that wasn't what got him almost impeached. It was the lying about it under oath. Yeah. It's supposed to work the same way today, so I'm still waiting to see what happens with this presidential administration, whether there's anything like that, but that's a political discussion for another time.
All right. As I can give a good example of this, a friend of mine decided to acquire some not so clean material.
Okay.
And then his hard drive, apparently there was a file associated with what he acquired that stated that he was under watch by a specific government entity, and he was like, "Hey, can you get rid of this for me?" So I basically it vanished for him. So
I don't know what exactly you received, but there was a very, very well-known scam going around that made people think that they had received a copyright notice from the FBI, and they did not. And it was just a scam.
Yeah, that might have been associated with it. So
yeah, Aaron's got the right idea. And then Aaron, you said something about erasing the SSD. The problem with the case and other cases like it, and there are now thousands of these, and I'm not even exaggerating, there are over 6,000 of these file sharing cases. The problem with erasing is that we're in civil court, and that can be seen as not just as destruction of evidence or perjury or what we call spoliation, which you would think it would be spoilation, but it's spoliation of evidence. the judge then takes that and uses it against you, pretending that what you were accused of having was on the drive, and that's why you had to destroy it. It's called an adverse inference, and it really can be used against just erasing it. So it needs to be preserved as it was from the moment that you got the notice, either to preserve it or notice of the case. And if you didn't, it could be used against you. Could be. It doesn't have to be in every case, but it's up to the prosecuting person, plaintiff or government, to then charge you with obstructing justice or spoliation of evidence.
Yeah, because it's important to say, well, this is my side of the story. If you can prove that you didn't do it with your hard drive, then you're innocent until proven guilty, right?
Yeah.
Yeah. Okay.
In criminal court. In civil court, not so much. In civil court, it's more like 50-50. It's like a football game where the object is to finish, is not to cross the line as many times as possible. The object is to get the ball to the opponent's side at the end, by the end of the game. So the whole game is like this back and forth pushing of who is going to get more evidence and testimony and argument on to their side and in favor of their side, and then keep it there and not let it be discredited or not let it be taken apart or thrown out. And whoever's got the ball on their side at the end of the game wins. That's it. That's civil court.
We saw a good example of this with the digital homicide case against Jim Sterling, where they were going back and forth with claiming evidence and Jim being like, this is what happened, and they're claiming something else, and but just totally back and forth.
That would be like watching a tennis match with Roger Federer playing Ethan Klein. You might get some volleys going back and forth, but it's just going to be Roger having fun until he's ready to smash, right past. And that's a bad analogy because I actually think Ethan's going to win the other lawsuit, so we should adjust that one. But that would be like Roger Federer against Matt Haas. There you go. That's the analogy.
Yeah, there you go. Yeah, recant it. We'll recant that.
And Aaron, yes, it might have been a joke, but it was also a really good opportunity to talk about that.
Yeah.
Yoshi, I'll be right there. Thanks.
And all right, so we'll go ahead and move on to question number 3.
Yeah, go ahead. Sorry, I had some backroom things going on here.
Okay.
I apparently have staff now. This is very nice, good. Actually. I really like having my assistants.
That's a step up, having assistants. All right. So question number 3. What is your experience being a copyright attorney?
Well, we talked a little bit about it. I'll continue the story since then. The world of copyright exploded sort of after and sort of because of that case. And there were over 5,000 lawsuits filed in the ensuing 3 years. Well, 5,000 total over the course of 4 years, from about 2012 till 2016. And then probably about another 1,000 or so in the last year and a half. So in total, about 6,000 of these copyright lawsuits have been filed around the country against file sharers, people who use the Pirate Bay, people who use other their BitTorrent tracker websites, and even some, at least this is just from anecdotal reports, so I'm going to put this out there, and I'd like the community to tell me what their thought about this is. Has anyone used, and please don't go use it, but has anyone used popcorntime.io? Because I cannot go and risk using that even for research purposes, but it's my understanding that it's sort of an embedded BitTorrent client, embedded in like JavaScript or something into a website that makes it look like you're doing a Netflix style, playing a movie from a selection of movies, but it's really streaming it through BitTorrent over the BitTorrent peer-to-peer network. And sorry. So popcorntime.io, people were getting sued for that as well, for using BitTorrent. And then I've used that a little bit to springboard a larger practice. I now do some local cases and things like that. But the YouTube channel has now become maybe a third of the time that I spend working in a week, researching new topics, interacting with the community, working on making my production quality ever slightly better every time. And the hardest part, finding and writing new content that is interesting for everyone to watch and trying to get it uploaded in a timely manner while also maintaining my other responsibilities. It has been a real challenge, and I'm looking forward to when one switches over and I can focus only on the couple copyright cases that I really want, and the rest of it be educational content for the community.
Yeah, because you can, what because you have a bigger profile now, you can decide which cases that you want to take, basically, and then maybe you could even start your own company and then have other like other people working for you, other copyright attorneys that would be able to cover other cases for you.
My biggest competitor does exactly that, but I'm the lone wolf. I could probably have applied to any number of other firms who were doing the same thing that I did, or I could probably have hired a number of people to do the same thing that I do. I'm very much a lone wolf, and I need to trust somebody like I would trust a spouse before I will get into business with them. But I'm also lightening up as I get a little bit older, and maybe I'm getting better at identifying the mistakes that I made in the past and learning from them. So I think those opportunities will be there as I grow a little bit. I'm definitely enjoying my experience here with the YouTube community and the new media community. So far, this community has been more supportive than even like my own childhood. So this is really kind of nice to have you guys all so interested in the content that I am creating. Wow, everyone's just trying to get a hold of me right now while we're on stream. Let me hit do not disturb on that. That's my bad. Sorry about that.
Okay, well, we were talking about landmark cases. One of the ones that springs to mind is Napster.
Okay.
That's a huge. That was a huge copyright issue back in the day.
It was.
People were downloading all sorts of music and what have you. Now, discussing Napster, and you were talking about Popcorn.io also. Are there other applications that have made it into the courtroom that have been ruled for or ruled against based on how their internal workings?
Well, sure. So Napster was just pretty much straight out because that was a centralized server, whereas on the exact opposite end of the spectrum is BitTorrent, which is still operating and has not been successfully sued, at least not that I'm aware of. And they've, in fact, the BitTorrent organization has contacted me through Twitter, more or less mistakenly asking me to stop talking about piracy and BitTorrent because they're afraid that the two will get linked. And I had to make clear to them that I'm a defense attorney, that I will always make clear that the two are not linked, and that no, they're not going to stop me from talking about it. So, there's that.
Yeah, because file sharing and piracy are not the same thing.
Correct. So, in the middle, LimeWire got sued. Like the whole Nutella network and the clients that supported them got sued. Again, because there was some proof that the central body was still, the purpose was piracy or something. I didn't prepare anything on that particular case for today, so I'm not 100% familiar with why LimeWire was liable besides for the massive copyright infringement, but like how you got there. But and anything else since then, there was one that began with a K, there was a BearShare network or something. Those were all similarly shut down, if I recall correctly.
BearShare, I do remember. K was Kazaa.
Mega Upload was also...
Mega Upload?
We should do a whole series on Mega Upload. That's still going on, that whole saga. And it's been, what, 4 or 5 years now?
Yeah. Kim.com, the Australian millionaire.
Who raids who with helicopters and dogs and guns for copyright infringement? So go ahead and just, I mean, even if you think he's got his finger on a button, he's going to blow it all up. Okay, so he blows it all up. So go get the adverse inference I was telling you about before. No one has been hurt. You didn't put anyone's life in jeopardy. I mean, even just flying a helicopter in there comes in with some sort of risk, and that's just unacceptable for something as dumb as a copyright accusation.
They took it to a logical extreme.
It seems like when you have such a disproportionate response, you should automatically be wondering who's behind this and why. And to me, it seems like it must have been somebody's money behind this, because otherwise, who the taxpayers are paying for all of that? I mean, yes, of course they are, but who's going to justify that to the taxpayers? So I got to do a whole series on that one. There's so many details there.
Yeah, but it is a court case. But where would the court case be handled? Would it be handled in Australia, or would it be handled? What country has the jurisdiction?
They are still fighting over that. I think the last thing I heard was that some part of it agreed to be heard in the U.S. or something. I might be getting it confused with Julian Assange, because both of them are going through the same thing for different reasons. But yeah, I believe the judge in New Zealand. I think Mega Upload and Kim.com were in New Zealand, not Australia.
Oh yeah, New
not
Zealand.
not that, you know. I mean, for the overall story, it doesn't terribly matter. But I do understand that those two countries do not like to be confused. So yeah. I think he was in New Zealand. And I think there's currently a fight between whether they can extradite him for criminal copyright infringement to the U.S., and I think he's fighting it. I do not have a clear update on that one right now.
Okay. All right. Well, now the audience, you see how this issue is it's a little bit of a mire right now. It's a swamp, and it's quite a gray area involved in this topic.
Ryan Roberson has a question. He asks if it's okay to watch and pirate a movie if he already owns a copy of it, if he already owns a disc. And I think a lot of people would agree with you that it's okay. It's not okay under copyright law, and you risk either getting a copyright notice at the bare minimum, or potentially having a copyright suit if you download the wrong movie. For example, London Has Fallen is currently suing people. So the problem is that they don't know whether you downloaded it for your own because you thought you had a right to, or because you're just freely downloading movies. So they'll sue you if they sue people, and you'll get caught up in that. And then you'll try to make a defense of, but I own a copy, and then it'll be a big, long, drawn-out court battle over whether or not owning a copy was licensed to own a copy in a different medium. And it's not. The law is actually well settled on this. When you buy a copy on CD, or in MP3, or AAC, or whatever, you own a license to that copy in that medium only. And if you go and download the entire collection, let's say you bought the Beatles collection and you just want to keep it shrink-wrapped for collectability, and you're just going to go download what's freely available from so many sites, the entire Beatles collection, then you're still guilty of massive copyright infringement, basically, because you do not own a license to have it in that new medium. That doesn't make a whole lot of moral sense. Like our gut feeling is, but I paid the artist for a copy, so I get that. I don't personally judge anybody who does that, and I may or may not have done that myself, but I could get sued for copyright infringement if I did that.
Yeah, because most CDs, their format is actually .cda. So when you do upload them to your computer and you do change them to MP3, that does change the the format of the content into a different format. Okay. Anyway, yeah. Licensed media contain. Yeah, licensed media container.
A couple more people have questions. Ryan asks for an update on the H3H3 lawsuit. I actually do have this one. Ryan, there is no update. Is that a complete enough update for you? I'm so sorry. No, really, I check this every day. I check the docket every day. I check it sometimes twice a day. I did check it late last night, and there was still no new filings since the 17th of March, including Matt Haas's surreply. So it looks like we're not getting Matt Haas's surreply, and we're just going to wait for Judge Forrest's ruling. I have seen judges take more than 6 to 9 months to rule on things. I did not and do not think that Judge Forrest will take that long, but there's nothing anyone can do to move her along, except maybe her clerk. And I wouldn't bug her clerk. That will not work out well for anyone.
All right. So Brian had a statement. You bought the movie and downloaded it, so there is no profit loss. Yes, there is still profit loss. They can still claim your download as a loss.
Well, yes, that's true, but even then, I can still eviscerate that in it with a completely different argument. Even if you claim there's no profit loss, guess what? I don't have to show actual damage. I can rely on statutory damages, and I don't have to show a profit loss. I just have to show copyright infringement, and then the judge gets to decide how egregious your copyright infringement was on a scale starting from $750 for one infringement to $150,000 for one infringement. So obviously $150,000 is a really big number and is meant for the most egregious of cases, but 750 is a big number, and that also includes attorney's fees. So if they had to sue you and hire a $3,000 attorney to get the $750, you owe them $3,750 plus interest. So that becomes enough money where attorneys get interested, and that's why attorneys are now filing these 6,000 cases in the last 5 years.
All right. Let's go ahead and move on to the next question. Do you have any advice for future copyright attorneys?
Yeah. I have a couple things just off the top of my head. One, you live in the age of new media. Figure it out and embrace it. A lot of people haven't figured it out, lawyers especially. We're starting to, so get off your butt and figure it out. But anyone who can stay technologically, culturally, and socially ahead of the curve and become an attorney and maintain all of that should be able to do well. That said, becoming a copyright attorney is not necessarily more difficult, but it has its own unique difficulties. The copyright is only practiced at large in so many places, like New York and L.A. I don't know why I wanted to say San Francisco. That's more patent law. You will definitely have an adequate amount of copyright in the Northern District of California as well. So California and New York City are basically the two big places for copyright. Florida's catching up. I think Miami, is it Dade County? I forget. Is starting to catch up with getting a fairly good amount of copyright cases. When you're ready to become a copyright attorney, go search for the copyright cases and start looking over them. Be prepared to spend a few dollars looking, over actual court records on Pacer. But it has never been easier. It's been very hard, and so this is really the easiest time to get into copyright that there really ever has been. However, it's going to have its own unique facets. Now, I went to school 6 years ago, so this advice may be dated, but my school, Widener University, made a big deal about keeping us off of social media, making sure that we didn't post things to Twitter, and didn't spend a lot of time educating us in the opposite direction of rather how to use it properly. That was maybe only a little bit of the presentation, and a lot of it was looking at the disasters of lawyers on social media. Pretty much the opposite was true. You certainly don't want to post negative things to social media, and even to an extent, my almost slightly disrespectful nature in being so informal with my hats and my shirts and everything. That is sort of offensive to some old world lawyers, and I've been contacted and asked to take some things down because some very ancient attorneys don't understand how the world has changed. Also, that there used to be very limited free speech rights for attorneys too. That didn't change until the 60s or 1960s or 70s. So basically, embrace new media, own your social media profile, do things that your clients would appreciate. So, for example, I'm a traffic attorney, I'm going to be making a video that I'm not publishing to my YouTube channel, but I'm going to be making a video about traffic cases, and clients who hire me will get a video first, a video introduction, all about their traffic case. That's awesome for me because that's half an hour or 15 minutes or whatever of exposing them to me and my method and my information that I'm going to give them, that I'm not sitting there explaining the same thing over and over and over again for the thousandth time. And then when the client comes to me and we meet for the actual meeting, they'll have real questions, they'll have the background knowledge, etc. Didn't really used to do this. Oh, I mean, some attorneys, I'm sure, did video introductions and things, but it wasn't as easy as it is today. And certainly all your competitors are doing it now, so you'd better do it. So if you want to get into being an attorney, one, you got to learn how to market yourself. Pretty much even if you're not going to be the front side of a law firm, you still have to know how to market yourself. And then to become a copyright attorney, you're going to have to really understand the facets of the copyright industry. If you get to know people in the industry and you're good at the political schmoozing and networking, they call it, good for you. I'm not so very good at that. I tend to, as you see here, have very little respect for unnecessary formality, and I don't always do well at those networking events. But so if you get good at that, that could also be a really easy way in. Find people. Well, that's just a really good piece of advice for anything. Find people who are doing what you want to do and talk to them. I think you'll be surprised at how easily they'll talk to you about everything they love to do.
Very, very informative. All right.
Ryan D asks, what do you mean by lawyers having social media disasters? You can Google some of them. I don't know if you can Google social media disaster. I'll try giving you one. Try Googling Recusal versus the internet. I'm gonna post a link here. I have to remember how to spell it. I actually had a friend of mine who was involved in this case. It's Rakofsky. Recusal versus the internet. Recusal was a new lawyer who managed to get himself into trouble by taking on a criminal defense matter that he eventually showed to everyone he was not competent to handle. And as I said before, lawyers always have a duty of competency. If at some point during the representation I discover that I'm not competent for some reason, I have to recuse myself. And the client has to get another attorney, and I have to deal with the consequences of that, whatever they may be. Recusal mishandled a criminal defense trial, a capital, if I recall correctly, a capital, death penalty involved criminal defense trial. And when reporters noticed his ineptness, they wrote about it. When other lawyers, like me, but I was not an attorney at the time, or may have just been becoming an attorney, they wrote, when other attorneys wrote about it, he sued them. He turned around and he sued his school and all the attorneys and reporters who wrote about his inept handling of the case. And he lost. He lost all of the lawsuits, except for one. His own law school, apparently feeling pretty bad about the situation, paid him a settlement. So that is a maybe not an example of him, it's not an example of a lawyer posting a picture of something and it blowing up, but it is an example of an attorney not understanding how the internet works and trying to take down information that he did not have the right to take down, and instead causing a Streisand effect and getting a lot more attention than he probably needed, at least at the time. We're sorry we didn't teach you better. Yeah.
Okay, now you brought up the term recuse yourself. This has been in the media lately because of a specific official having to recuse himself from specific events going on in the government. Can you explain what recusing yourself means?
Well, there have been a couple of those, so I'm not entirely sure which one you were talking about. If we're talking about Jeff Sessions with the Michael Flynn investigation, or if we're talking
Yeah,
about
that
that
one.
judge who didn't sentence somebody to death and then went to an anti-death sentence rally as a figure in the rally, like as the death guy on the stretcher. Um, when when you have a conflict of interest or some other legal responsibility to withdraw from something, that is usually called recusing yourself. It's usually you don't someone. I don't recuse you. I don't cause you to be recused. You recuse yourself. It is something that I have to identify usually with the help of someone else, but I have to identify when the time is and then remove myself gracefully from the situation. This happens in conflict of interest cases a lot. Attorneys always have to do a conflict check to make sure that if we're working on a case for John Doe, that we didn't represent somebody who is hostile to John Doe and know all sorts of inside information that we're now going to know inside information about two people who are hostile to each other. We're not allowed to do that. That's called a concurrent conflict of interest and an absolute zero tolerance no-no for attorneys. The only way we're allowed to represent is if both parties are informed that we want to represent them both, and then we tell them about the conflict of interest, and they sign a document that says they're fully aware of it and consent to it. So if someone has a conflict of interest, or a judge, for example, I had a judge, I was representing somebody in a custody case, and we went to court one morning, and my client runs up to me, panicked, "Mr. French, I can't go before this judge. I know this judge. Worse than that, I campaigned against this judge. Like, I went and actively said, don't elect this judge." So I walked up to the judge and I said, "I've never done this before, Your Honor, but my client says he knows you and maybe you should recuse yourself." And she said, "Oh, yeah, yep, we'll assign him to another judge." I was sweating bullets. I thought I was going to get in trouble or so. I didn't know what to do other than I knew what had to be done. But asking a judge, to recuse themselves, you don't know how that judge is going to react. So I was very grateful that the judge just, "Oh, yeah, sure. Yeah, definitely." Definitely don't know that. Definitely don't like that guy.
All right, so this is kind of comparable to like when you have a jury trial. If a juror knows about the situation before entering the jury pool, then they should not participate as part of that jury pool because they already have a bias for or against the defendant.
Yes. And if someone finds themselves on a jury pool, and more than just not wanting to be on a jury pool, but they have such a conflict of interest, usually it's as simple as calling the not election office. Yeah. Whew. There is an office that handles these things. Some chat reminded me, it slipped my mind. But you call the court and let them know that you can't for some reason serve jury duty, and they will reassign you to either a different jury pool or something.
Well, okay, like talking about not to bring up an example from the past, like the OJ case.
Mm-hmm.
A lot of people heard about that before they even decided on the jury.
Right.
So they probably went through a lot of people before they were able to assemble a competent jury that was not either biased for are biased
Yeah.
against him.
And I believe they had to sequester that jury, and they had to keep them away from news and newspapers and things like that for the duration of the trial, or at least that's what sequester means, whether or not it was OJ. And yes, you can taint the jury pool by having access to information ahead of time, or information that's been opinionized or editorialized or just organized by an outside source. And so that's what happens. And that's what Matt Haas actually, was it Matt Haas accused the Kleins? Yeah, I think it was Matt Haas in his third count accused them of trying to taint the jury pool or something like that. I don't think that was Jim Sterling, but somebody correct me if I'm wrong.
Now, now, when we're discussing this, is this a copyright case? The H3H3 versus Matt Haas.
Yes. What about it?
Okay, the H3H3 Matt Haas thing is a copyright dispute.
Yes, it's a copyright dispute. The H3H3 Productions used clips of Matt Haas's YouTube video in a video critiquing, criticizing, making fun of him, and they monetized that video, and then he sued them for copyright infringement, claiming that they did not use his material properly. I personally don't think he has a very strong case, or has much of a case at all, but he has persisted all the way to summary judgment, which is a very slight premature ending of the case, and we are waiting to find out what happens and how that ruling comes down.
So this is pretty much just a case of fair use. But is there a jury involved?
There is no jury involved. A lot of times, copyright cases don't involve juries because you can hear all the technical stuff that we're talking about here. Now try convincing your average or even below average, and I mean that with no offense. I just mean that you're going to get people who do not understand technical things in the law. And so you're going, as an attorney or as a party, you're going to have to whittle that issue down to something much more accessible to the average person. And then try to imagine this. Imagine you are just sitting. You can't have your phone. You can have a pad of paper, but it doesn't have anything written on it. You can take notes. Maybe, if they let you, you can take notes. And that's it. You sit there for 3 hours in the morning and 3 hours in the afternoon, listening to a case and doing nothing else. How long are you going to be able to pay attention when your mind doesn't wander? You don't miss a fact here or there. That's your average jury, and so many of these cases don't use juries. The parties consent to a bench trial where the judge does the finding of fact. That's the jury's job. The jury finds which facts are true. You present your case, I present mine. Your case is different than mine. The jury doesn't decide who broke the law. The jury decides whose facts are correct or which facts are correct, and then based on that finding of fact, either the chips fall directly into a crime being committed or a claim being recognized, or the judge will then later on connect the dots from the facts to the law.
Okay, so juries are mostly used during criminal cases, right?
Yes, that's where everyone's familiar with juries or criminal cases.
Okay, to decide whether somebody is guilty or innocent of a crime,
right?
Of committing a crime. Okay. Now that we've established that, okay, we're learning stuff today.
That's the goal. Okay, Clench Eastwood says, Leonard, do you enjoy being an attorney more or less than you thought you would when you started law school? Clench, it is. I enjoy it as much as I thought I would, and I'm surprised by all the ways that I didn't realize I would enjoy it. That said, it was a winding, twisting road to finding my happiness in being a lawyer. If I had made the mistake, and this is subjective, this is a mistake for me, I do not expect this to be a mistake for anyone else. If I made the mistake of going into practice with a let me choose my language carefully,
Mm-hmm.
with a strict, old, traditional law firm where I was given the crap work at the bottom. I served my superiors as a lackey and had to earn every drop of respect from zero, I would not have done well. Instead, by taking the chances that I did, I started at a place where I had a little more control, but also was nearly 100% naive. Some people, I have a friend in New York. He's an Emmy Award winning videographer and producer and editor. He loves and thrives in that environment. It's not that he wants to be a lackey, it's that he knows that if he plays the lackey game right and he works his way up, he can become a very powerful person in an organization. Have opportunities that I will never have because I cannot transition from here into there very easily. This is now kind of its own thing, and I have to own this for the rest of my career, basically. So it's really a matter of opinion, but I would not thrive in that environment. I speak my mind too often, and I have very little respect for authority that hasn't earned their authority, if anyone understands what I mean by that.
Yeah. Yeah. So, yeah, doing the lackey thing, being on the bottom to get to the top, is...
And I've done that, which is also why I don't want to do it anymore.
All right, now, are you allowed to disclose which college you went to for your
Oh
degree?
yeah. Well, actually, it's I went to multiple colleges. I started my undergrad at the University of Delaware for electrical engineering, but I had a whole bunch of personal things explode for me. My girlfriend cheated on me, my family lost the business, and I got overwhelmed with the pressure of succeeding in school. And when I started having trouble in math, I didn't ask for help, and I didn't seek tutoring. I didn't tell anybody I was having trouble, and I just kind of let myself into this downward spiral of all these life circumstances. So I did not finish my engineering degree at the University of Delaware. Instead, I finished a IT degree at DeSales University, a local college near me. Became a university after I started going there. And from there, got a master's degree also in IT from the University of Phoenix online. Still not sure whether that university was a great idea or not, but at least I had a decent educational experience. And I do say that knowing that I'm on camera and knowing that people are suing them for having less than decent educational experiences. I'm not trying to back them up. I'm just saying that I worked harder on that master's degree than I worked for a year of my master's degree at the other college. So I don't really know. I still don't feel like I got a complete education. But then again, I went to law school and still didn't feel like that was a complete education because that doesn't actually prepare you for the practice of law. I went to Widener University in Harrisburg, Pennsylvania, mostly because they were local to me, also because my LSAT scores and grades and things were average, above average, and I probably wouldn't get into a higher tier law school, at least not as easily. And at that point in my life, I was looking for something that wasn't going to be difficult. I wanted my law license. I didn't want. It certainly was going to be its own challenge. I didn't need to add to that challenge with extra challenges. So I went to something attainable for me, and completed my. I did a 4-year degree. I did a night school. Went to school from 5:30 to 10, 5:30 to 9:30, 5:30 to 10 at night in Harrisburg while living in Allentown, which was 86 miles away, and while working in Coopersburg, which was another 10 miles away. So it was like 100 miles to get to school, 86 miles to get back. And I did that for 3 times a week for 3.5 years. Did some study abroad in Italy for a month. That was amazing. We could do a whole episode on that. And then finished my degree in Harrisburg after my fiance broke up with me. So that was all sorts of challenges all around. And so that's how I got my degree. I studied for the bar, I'm an auditory learner, so I was very grateful that Barbary had audio lectures, and I basically studied for the bar from the audio lectures. I almost didn't use any of the written materials, other than studying what format the questions were going to come in and what to expect from the MBE. I did a lot of the multiple choice questions ahead of time. Probably a couple, I don't know, at least a dozen times went through the 500 question pool that they had. I studied for that. Did all of that while I was bicycling around Harrisburg. They have a bicycle path that goes most of the way around Harrisburg. And so I would do 20 miles a day and study for the bar. Passed the bar, took the bar, thought I failed because it's very hard. You really can't tell. Um, Waited the 3 months to find out about my results while planning to continue my previous engineering career, and found out I passed. Instantly started my law career. Probably about 2 months behind because I should have been preparing to start the law career before I got the license. But I honestly didn't think that I had passed the bar, and I passed it by an okay margin. And I did really well on some of the questions too. It was all here. It was all up in my head, making mountains out of molehills, which I still do to this day. I'm a human being like any person, and there you go. That's my answer.
Now, a lot of the colleges you mentioned, they are definitely not Ivy League.
No.
Now that puts the question: is an attorney who graduated from an Ivy League school such as Harvard, are they better or worse at their job than somebody who went to these second tier, third tier schools?
You know I have Harvard viewers, right? Okay, so how do I put this? And this is actually kind of a topic for a larger video that I want to make. A human being is a limited experience. No one person can know everything, and anyone who's arrogant enough to think that they have all the answers is wrong. They're not necessarily wrong that they probably have some of the answers right, and they probably are on the right track. They're thinking skeptically, and they want to have answers, but that doesn't convince other people, and that also doesn't leave you open to the natural skepticism we need to have as lawyers to function in our jobs and just generally in the world. A Harvard lawyer is well trained as a lawyer, and I would expect them to be able to jump into any purely legal project and be able to complete it from an academic standpoint with outstanding results. However, isn't that an enormous amount of pressure as well? Is every smart person capable of handling that pressure? Absolutely not. So they're going to be good at handling their experience. Just like I can't walk into a Harvard lecture and school them. They don't have some of the street smarts that I have. They don't have some of the small business smarts. They haven't been screwed the way I have been in some time. Nor have I had the opportunities that they've had either. That said, I have some Ivy League friends who went through hell to get to where they are, and it's very possible that they have all the street smarts and more, and all of the education and more, and the resources and more, and they know they're lucky, and they don't take advantage of it beyond the normal advantage we're all supposed to take. They don't take advantage of other people in an unfair way, and I absolutely respect them for it. So both sides of that. Harvard or Ivy League doesn't automatically mean you are the world's greatest attorney or that you can handle a negotiation in the back room. It does mean that you should have an extremely good education, and it should mean that you had all of the opportunities, educationally at least, to get your, a very complete law education. That the other side of that is that every person is limited, and we can all be amazing in our own ways.
Okay, that that's a good A good
I
attorney.
tried
A
not to
good.
bullshit the answer. It's not a bullshit
Yeah.
answer. I'm trying not to bullshit it. I'm not gonna say uh, anything derogatory about anyone. One, because I don't. I'm done with that. I've been an asshole. I'm not. I can still be a jerk, but not that way. I don't need to be derogatory. I can make my point and I can articulate myself without going there. And that said, I actually don't have any negative feelings towards the Ivy League or the elite classes and or anything. First, Ivy League doesn't mean elite. Ivy League, there are lots of people who go to Ivy Leagues who got there without uh, an elite background. And I don't mean elite derogatorily either. I just mean, people who have, generally more opportunities than the rest of us. I'm probably pretty close to that. Before my parents lost that business, we were doing pretty okay, and that's why I could go to the University of Delaware and not have student loans and that. But then, so that was kind of a culture shock for me. Was going from sort of a upper middle class to regular and possibly a little bit more frugal middle class than I was used to. And then I started my adult life at that exact time too. So I went from basically having most things just handed to me to needing to do it all for myself from scratch. And so that right there is an opportunity that someone else may not have. Will I go so far as to say that everybody from Harvard didn't have a difficult? No, absolutely not. I bet you lots of people from, I keep saying Harvard, just I like the word. Lots of people from Yale or Harvard or any one of the other 11 Ivy League schools that I can't name. Um, I don't even know how many there are. Someone's going to correct me on that. It doesn't mean that they've had worse or better experiences. It just means they've had different experiences. So I guess what I'm trying to say is that we all need to work together in a sense. No man is an island. Here the lone wolf is saying that. And as an attorney, I would say everyone should be completely aware of their bedside manner and simply not making assumptions about their clients, about the other lawyers that they've come in contact with. Um, some of them may come from very well off backgrounds and very well educated backgrounds, and they may be extremely pleasant people because of it. And there should be no reason why anybody should treat anybody any differently. So and it works both ways. At the same time that you have the benefit of being able to be a Harvard lawyer and the prestige with which that comes, you also got the pressure to perform and keep it up.
All right. That's a fair look into the way you think. um, I had something and then I lost it because chat distracted me. All right. All right. So let's go ahead and jump into the last question. What future projects do you have on the dockets? Slash, do you know any future events that you will be involved in regarding copyright?
What can I talk about? Well, the future of my career is probably in this channel and in other copyright cases that people choose to hire me for. That's not a solicitation. Um, and this video is not a solicitation for future business, but the attention that this channel has gotten has brought some more business, and it appears that I'll be representing more and more people who are involved with creating new media, Twitch, YouTube, uh, multi-channel networks, and content agreements and things like that. I met with the video game attorney Ryan Morrison and his partner, the geek attorney Michael Lee, last week in New York. They're awesome guys. They're just like any of us. They play video games. You know, they're just regular human beings like us. It's really cool to see that the stuffy world of attorneys is finally breaking down, and we're just regular people now. And there's just so many opportunities. The esports world, for example, is growing Michael Lee is involved in litigation around the country. I think he was in San Francisco or L.A. or something this week. And the video game attorney is constantly doing esports deals around the world. So that's it's just a new it's a new world. There's so many opportunities out there. So what I'm doing is this, and who knows where this is going to go. I did not a year ago. I did not expect to be doing this. I expected. Well, I don't know what I expected. I guess I expected more of the same copyright cases, more of the same file sharing cases that I was doing before.
I remember what it was that I was going to say. Because you're cursed, this video is now demonetized. And I don't care.
Yeah, that's the YouTube ad apocalypse is kind of interesting. I've got about half the revenue from April as I did in March, but I did do a much better job on my videos in March as far as getting them out on time, and the topics were more popular. And my video, the 3 videos that I put out in April were about the United Flight 3411 thing, and those videos got less than half the revenue that my other videos get. Click for view for view. So that's probably because YouTube got better at pulling ads from controversial videos than that those videos actually were more or less controversial than they used to be. So yeah, I do consider it kind of an adpocalypse. It's not going to stop me from making content, but if something else comes along, I'm not necessarily 100% loyal to YouTube. But so far, YouTube's doing a great job trying to keep uh, towing the line down the middle between getting sued into oblivion by major content owners and appeasing the upcoming and now established content creators.
Well, okay. Since you're talking about moving away from YouTube, have you considered thinking about using Twitch or other avenues such as
Yes,
that?
yes, Twitch crossed my mind. I have a Twitch account under this name, and I do stream under it when I stream, at least when I stream games. But they don't have an upload system. Am I correct in that? And so I can't upload videos that I edited offline. And so I
It's
hadn't thought about switching over.
there is somewhat a upload option. They have, but they use VODs right now. But if you become you have to get a specific number of viewers or something
Oh,
like that.
okay.
A specific number of views for you to be allowed to upload. And also, they have, if you reach a certain point, you can become an affiliate with them, and then people can subscribe to your channel. And they just released this week, between this week last week, new tiers for subscribing to the channel. That's $10 level and $25 level.
Okay.
So it's,
I will look into that.
yeah, Twitch is it's becoming more viable,
Okay.
even though Amazon is in control. Um, that makes it both bad and good for streamers.
Well, I keep bugging Facebook to let me monetize videos, and they don't seem to care. So I'm not uploading to Facebook, that's for sure.
Yeah, there's also VidMe, or I think chat would be able to let us know more options of this, because while YouTube is the biggest right now, I think the time is coming for somebody to fill their shoes. Well, while they're big shoes right now, I'm sure there's one of these smaller
You
companies.
know they bought a whole building in Manhattan, right? It was like $2.2 billion.
Now, was that YouTube or was that
That
Google?
was Google, but it's right next to the YouTube studios.
I see. So they are. Well, that could involve more of the YouTube Red
Yeah,
stuff.
but you're right. You're right. Someone could still move in on YouTube because it is a separate property, and and like other things, Google would shut it down if they didn't think it was working.
Yeah. All right. So anyway, all right. So let's go ahead and turn it to questions for the audience, which I should have said um, from the beginning to leave all the questions till the end. All right. So the hopeless Brit. What is your opinion on Germany requiring you to buy a broadcasting license after a certain number of viewers. Now, I heard about this story too.
Wow.
Also, yeah, I heard about this story too. Also, if you have above, I think above 2,000 concurrent viewers, you have to buy a streaming license, because then you count as a radio broadcast or a television broadcast, and the licenses can go anywhere from $1,000 to almost 10K, depending on how big you are. And if you don't pay for these licenses before you reach that number of viewers, then Germany can decide, well, we're going to fine you that amount instead.
That would probably fall afoul of free speech rights in the U.S., but I don't know what Germany's take on free speech is. I'm assuming they have some kind of recognition of free speech, but then they also have some kind of recognition of broadcast rights, which is weird because that almost seems like a monopoly on the right to broadcast yourself. That's weird. That's weird. No, I don't like it. I'd need to hear the rest of it though.
Yeah, that's not fun. Let's see. Scroll up. Do you feel Twitch should come under broadcasting laws? I do not. I do not. The FCC should not be allowed to control what Twitch does and does not do.
Yeah, the FCC, does have the right to control broadcast in the U.S., but
do they have the right to fine you if you have too many viewers or have?
Yeah, I don't think so on the internet. But at some point, Congress could very easily make a law saying that the FCC now also has control over streaming and all that, which it may be. I am not an FCC or First Amendment lawyer, although I can talk about it a little bit, but I do not know exactly how broadcast and streaming and all that are regulated by the FCC in the U.S.
ACB THR brought up the issue with Twitch uploads is that they get purged when they reach a certain age.
Oh, okay.
So it's within, I think, either 2 weeks, 2 months. I think it depends on how much activity the VOD has. Well, let's see. Are you able to simultaneously stream to both YouTube and Twitch if you are an affiliate? I don't believe so. Because if you're a Twitch affiliate, they specifically want you streaming on Twitch, thereby supporting their revenue stream as it is. Also, Amazon has the Twitch Prime thing, and I've heard a little insider baseball that with every Twitch Prime subscription, Amazon's actually losing money. But with that, Amazon has so much money to begin with, to work with. I mean,
well, they have to.
Hopefully,
oh, sorry. Go ahead.
Hopefully, it balances out to where the Twitch Prime subscriptions equivalent to where they're not in the red and where they're just above the black.
Well, I think they're actually really forward thinking, and all of this may be a little bit ahead of its time, but since there's so much competition and someone wants to be on the ground floor when it reaches Malcolm Gladwell's tipping point, basically. So 10 years ago, people thought online video was kind of ridiculous, and I mean people in general. Nowadays, people are starting to transition in masse. We're starting to hit that tipping point where people are cutting the cord and moving over to on-demand video. We finally have DirecTV now. We have YouTube TV and some other services. But it's still not quite there yet. We still have cable, and we still have packaged TV and bundled TV services, which we'll always have. But I mean, that's still a major, major push. YouTube has not taken over yet. Twitch has not taken over yet, but it is now making billions of dollars in impact. And that's gotten companies' attention, and now they realize that if they don't invest in this now, they're not going to be able to get in on the ground floor for the same low cost later. So maybe it is a little bit of a loss leader for Amazon, but when when it comes around and the rest of society or culture, or it's more culturally involved and there's more money flowing through it to the creators and therefore also to Twitch and etc., then I think you'll see those other major broadcasting companies either scrambling or they will have begun scrambling already to try and catch up.
Well, they kind of are with the whole Wall Street Journal PewDiePie incident.
Oh yeah.
It,
If you can't join them, beat them.
Yeah, exactly. But also the thing is with the well, Boogie2988, if you've heard of him, he made an interesting point. He thinks that these ad companies are trying to make the ads of YouTube, make them cost lower. That way, they won't be spending as much money to advertise on YouTube. Boogie thinks they're trying to drive.
That's a really good one.
Yeah, drive the cost down, which I agree with because of the fact that a company has to rely on how much profit it's making, and if they're not gaining enough profit because of their ads being on YouTube, then they will take their ads off, as we've seen with a lot of companies leaving YouTube to begin with. What they're probably doing is waiting for the cost to lower and saying, "Oh yeah, we'll throw our money back on there, regardless of what the video content is." And then YouTube starts making money again, and then they start charging higher. It's a vicious circle.
All right. That's a heck of a plausible conspiracy theory, actually.
Yeah, tinfoil hat here. All right. Anyway, okay. Leonard, what made you decide to go the silly hat casual route with your videos? Vice completely straight. I don't know what that question is, but the basic gist of it. What made you use the silly hats?
It was kind of by accident. The first law video that I made was the Fine Brothers reaction, or my reaction to the Fine Brothers trying to trademark React. And I hadn't planned on it being viral or getting 100,000+ views or anything. Most of my videos got like 3 views, so I was just pissed off, and I made a video. And I think it was me in just like a t-shirt or something and a winter hat. And it was only a winter hat because in this room it's kind of cold during the winter. So I wore my hat. Who cares? I'm not just making a video. And it got over 100,000 views. And at that point, people had already said, I like the hat and everything. And I have no overall... I overall like wearing the funny hats because I have almost no respect, like I said, for unnecessary formality. Everybody's used to your top-notch lawyer being in a perfect suit with perfect hair and everything. And that's true. I do myself up when I'm going to go to court, so I look the part. I don't want to distract my client from my client's case. I don't want to distract the judge or distract whoever else is in the room from the case that I'm trying to make.
Yeah, you actually talked about that in a video once.
Yeah.
That you wouldn't go into a courtroom wearing
my earring.
Wearing an earring. Yeah.
Yeah. Thanks. That's cool. People watch. Yeah, that's cool. And so here. This is me in my house. My bedroom is 20 feet away from me, and I'm just going to be me and have a good time with it, and the hats are just something to have fun with.
Yeah. Actually, talking about the Fine Brothers video, that was the first time I got subscribed that was the first time I've been exposed to your specific viewpoints, and I was like, hey, this guy's kind of cool. I like this guy. I'm going to subscribe to him.
Well, thank you. And I appreciate your subscription. And all
actually,
your subscriptions.
yeah, actually, I've been trying to get an interview with you for the past maybe 5 months.
Really?
And I was only able to do it because of the Discord chat.
There you go.
So
That's a great opportunity to pimp the Discord chat. I'll
yeah,
post the link to that as soon as I find it.
yeah, post a link to it. Even though I think most of your live chat is probably in there already.
Yeah, somebody in the
But
chat post a link to the Discord because I don't have it in front of me.
yeah, but it's not your Discord; it's your wife's Discord.
I am not married. That is
Okay.
a fellow fan, a fellow subscriber, Sarah. She does
Yes.
not want me to say her last name. She is Skeptic Sarah on Twitter, and she hosts the Discord just on her personal virtual host. So I'm very grateful to that and for that, and she also moderates chat and moderates the Discord as well.
Yeah, we're very grateful to Sarah, and I apologize for thinking she was your wife.
Oh no, that's okay. She's a very nice person. I'm flattered. I'm very single, so anyone who is applying for that role can feel free to apply. Haven't gone on a date in a little while, actually. A little bit bitter about that.
There we go, Leonard. We need to make dating profiles on YouTube.
Let's not, but
all right. And any other questions for the chat? Let's see. I like she called it lawful masses. That's good.
oh, Lawful Masses is mine. I registered and own lawfulmasses.com, and that's my brand. But we're going to share it for the podcast, and I'm going to probably use it for the videos at some point. But that will be the brand name. I just haven't had the guts to ask everybody to subscribe to a different channel. No. Let's establish the user base first, the viewer base first, before we go anything wild like changing the name.
So is Lawful Masses like a blog or something?
Yeah, it's lawfulmasses.com, LAWFULMASSES. And it's where I post my YouTube video links, where we post links to Sarah and my podcast. We've only done 2 episodes so far, but there will be more. And where further internet/media efforts will be posted.
All right, Kenjin. Well, Kenjin, I'll answer your question in just a second, but yeah, okay. Steven linked to the Discord, which is good. Oh, somebody, Ryan D. What does Esquire mean, or what does
That's a good question.
The initials at the end of some lawyers? What do those mean?
What it means that we are a licensed attorney. No one can call themselves Esquire if they do not have a law license. I believe it's an active law license. If you have voluntarily suspended your license, which we're allowed to do, then I don't think you can use Esquire for that intervening period. Just quickly looking it up on dictionary.com, it was a young nobleman who was in training for knighthood. And so it is no longer used in that way, at least not in the legal community, and instead is the formal title for anyone who has their law license. They are allowed to practice law and represent clients.
So lawyers are knights in training.
Yeah, basically. Yeah, there you go.
I kind of disagree with that. I think they're more sharks in training.
The pen is mightier than the sword.
Yeah, it is. The pen is mightier than the sword. All right.
Well, the pen orders the soldiers to take their swords against. That's where it's mightier.
Yeah, and right now the pen is in the hand of a pinhead. Just making a governmental observation.
Giorgio offers to take me out on a dude date in Las Vegas. Giorgio, I would definitely consider coming to Las Vegas to go on a dude date with you. That would be awesome. Why would one Katie R asks, why would one voluntarily suspend their license outside of being pressured to? Same thing here. So I have to do 12 hours of continuing education, which I actually just completed this week because they're due tomorrow, every year. I have to pay a $200 licensing fee. I have to maintain all of my professional and ethical responsibilities. For example, if I solicited clients on this video, I have to say something like, this has been attorney advertising, and none of this is intended to be legal advice. That's all true anyway, but they actually require me to say it in some places. I might not. I might pay a $100 fee, or I think some places an $80 fee, to suspend my law license, and then the state just puts me on the back burner and then puts my law license on hold. I don't owe any of those ethical responsibilities, or in some places I owe fewer ethical responsibilities, and then I pay a restoration fee later on if I want to go back in. Why would I do that? Maybe I'm making YouTube videos and I'm no longer going to litigate. Maybe I've taken a research position or an in-house counsel position and I no longer need to be a licensed attorney because I'm working under a licensed attorney. So an attorney can work for another attorney without a license. It's the person who's signing their name to the paper as the final, what I would call a Rule 11 signatory. In the Federal Rules of Civil Procedure, an attorney signing papers makes him or herself responsible for that signature and what the papers contain. So that means I can't just go take your frivolous case and file it. I have to find legal basis for your frivolous case. And if it's not, if it's truly frivolous, I cannot file it under my name or I will be in trouble just like you would be. So that's why we might suspend the license, so that we suspend those duties as well.
Okay, so a suspended license, basically, it's like
That's a voluntary suspension. I'm not talking about getting suspended for trouble. That's a completely different thing. If you get suspended for trouble, then you have to go through a whole different procedure, including all the unique things they make up for you to say what you have to do to get back into the practice of law, and then you have to go do them. Oftentimes, it's keep your nose clean, do something in furtherance of the community or the law, have some people testify about how good of a job you're doing. It's usually something along those lines.
now there's a difference between your between being suspended and being disbarred.
Correct. Suspended is more of a disciplinary procedure for when it's involuntary, and is just totally voluntary when it's voluntary. It means you still have a license, though. It's just not active. You can't use it. You don't have to reapply for your license. When you apply for your law license, it's approximately $1,000 fee or more. It's a background check like you've never seen, beyond what they do for guns, it's almost a government clearance level background check. It doesn't go into any kind of government clearance. I don't have any special clearances or anything, but they do that sort of background check. They want to investigate everything, every traffic ticket, every fight you had with your spouse. If you had like a domestic violence complaint or something, they want to know all about it. So it's that kind of thing. So you don't have to go through that again then. Or you have to go through a lesser background check for the reinstatement or something like that. Disbarred is completely losing your law license, and usually means losing it forever.
All right, because that happened to Jack Thompson, right?
Yes, it did.
Okay, the guy who was.
We couldn't be happier.
All against video games.
Couldn't have happened to a better example.
Like, GTA is a murder simulator. Only if you let it affect you that way. But
obviously, we would have had so many problems by now if video games led to that sort of thing.
Exactly.
I would argue that the drop in crime that we've experienced from the mid-90s till now has been because people have access to more stuff for lower cost through the internet and through phones, and fewer people are just sort of put in the corner to just suffer. People who are just forgotten about, they learn how to get back. And when you... So there's also the Freakonomics authors, Stephen Dubner and Stephen Levitt, have a theory that the legalization under Roe v. Wade of abortion one generation later led to a decrease in crime as well. Once again, because there's fewer people who don't have nothing. They have stuff. They've got opportunities. They can meet people on the internet. They can look up stuff that they need to find out. They can't be taken advantage of or abused as easily. And so I think that naturally leads to a lot of people just not committing as many crimes because they don't need to act out as much.
Yeah, because they can act out on the internet. They can be anonymous and say whatever they want.
And they do. And isn't
Yep.
that a little bit healthier? Isn't playing a video game a little bit healthier? Heck, even I am completely guilty of calling people names on World of Tanks. I will admit it. I am a jerk. I shouldn't do it. When my team dies for the stupidest things, sometimes I just can't help but tell the whole team about it and how much I think about it. And that's horrible. But also, it's a video game. And I would rather that I just let it out in a healthy way or healthier way than, let it build up and affect me in real life and stuff.
Exactly. Anger management.
Anger management. Now, ultimately, we want to be not angry, at anything, right? But we're human. Are we really ever going to be perfect? We're going to keep trying, and that's the most we can ask for is that perseverance.
Yep. All right. So I think that'll do it for the questions. The Discord's been dropped in the channel a couple times.
Okay.
Is there anything else you would like to show?
No, just on the point of that last thing, hopefully I don't get sued by the estate of John Steinbeck, but John Steinbeck once said, "It is true that we are weak and sick and ugly and quarrelsome, but if that is all we ever were, we would millenniums ago have disappeared from the face of the earth."
That is a good quote.
And he's a great author. I highly recommend you read him.
All right, so we'll drop. ACB said, "Bad Leonard, no shit talking."
Yeah, I know.
Leonard sues himself for defamation. All right, we got Lawful Masses. We got the Discord. You have your YouTube channel, and you have your specific attorney work.
Yep.
Which I'm not saying it. I'm not saying soliciting.
Oh no, you're okay. You can say whatever you want. I can't say whatever I want sometimes.
Yeah.
Tomorrow at 4 p.m. I don't know how I'm doing this yet because I have some ideas, but tomorrow at 4 p.m. I'm doing a scheduled live stream celebrating the 55,000 subscribers that I've got so far, and so I'm gonna try to come up with some fun stuff. We're probably going to do some confetti drops, and I'll probably read some things from a book about piracy, and we'll play with the dogs, and I'll answer your questions. So I'll see anybody who wants to see me again tomorrow at 4 p.m. Plug that while I can.
All right, and I'll be dropping all the links to his stuff in my comments, in my description, and also to clarify for your audience, what I do or what I produce on my channel are these segments, 5 Good Questions. I also produce product reviews. I produce video game segments, like a recent one that just went up was Marvel Guardians of the Galaxy Telltale game, which actually got copyright claimed because of the fact that there's music in it. So I doing a little manipulation of that.
I use not that I'm not sponsored by them or anything, but I use epidemicsound.com. They don't have a catalog of mainstream music. Instead, they have a catalog of private music, but it's rather large, and so far the streamers have enjoyed it. And I pay $15 a month to be allowed to use their music on my YouTube channel as like a flat fee. But there are some limits there. That's only the YouTube channel. I can't use it on Twitch. I can't use it on anywhere else. So.
Oh, okay. Then I wouldn't be able to use it because I would be using it on Twitch.
Well, I mean, I'm licensed for YouTube. They may license for Twitch. I don't know.
For Twitch, okay. Also, PlayerUnknown's Battlegrounds.
Yes. I suck. I mean, I get into the top 10 consistently, but I'm not very good at killing people. I'm very good at hiding. I'm like the sniper and the stealthy person, and I can hide all the way up into the top 10, but I can't. I can't seem to kill everybody with any effectiveness.
Do you do solos or teams?
I've been doing solos so far. I don't.
Solos.
Am I worthy of a team if I suck so bad? I don't know.
Well, from the guys I've been watching, there's only one really good guy, and the rest are just suck and drag along behind him.
Eastern time, Eastern Daylight Time.
Yep, Eastern Standard Time.
Eastern United States, New York time.
Yep.
All right, so is that it?
All right. Well, thank you guys.
Thank you all for coming.
Yep. Thank you for the audience.
Thank you for contacting me, and we're gonna thank each other at the same time. Is what we should do.
Yeah.
Go for it. Go ahead.
Thank you for coming on to this edition of 5 Good Questions and being a guest. And thank you for answering my questions in as eloquent as a way as possible. Also, thank you for wearing your hats.
Yeah. You're very welcome. Thank you so much for having me.
All right, so take care, listeners. We hope you guys have. We thank you for watching. Thank you for listening. Take care of yourselves and have a good day. And 3, 2, 1, we're done.
Okay.
Oh.